डॉक्टर बाबासाहेब आंबेडकर ओपन युनिव्हर्सिटी.
Good evening and namaskar friends. I am Dr. Dhaval Pandya welcomes you all from the Chaitanya studio of Dr. Babasaheb Ambedkar Open University. Today we are going to learn about MBA01, that is business law, and unit number 2, that will be Indian Contract Act 1872-II. So the code is MBA01C106, unit number 2, Indian Contract Act 1872. First, we'll see the syllabus and then we'll proceed. It contains discharge of contract, remedies to breach of contracts, performance of contracts, void agreement, contingent contract, quasi-contract, special contract. That covers 3 things: contracts, indemnity and guarantee, contracts, bailment and pledge, and contract of agency. In last lecture, we discussed about discharge of contract and remedies to breach of contracts. And what about today's lecture? In today's lecture, we will discuss about performance of contract, void agreement, contingent contract, and quasi contracts. We'll start with performance of contract. Performance of contract covers 5 things. First, promisor himself, agent, legal representative, third person, and joint promisor. We'll start with performance of contract. Okay. Few things, as we discussed, can perform a void contract. First, promisor himself. What is promisor himself? If there is something in the contract to show that it was the intention of the parties that the promise should be performed by the promisor himself, such promise must be performed by the promisor. Section 40. This means contracts which involve the exercise of personal skills, volition, or diligence of the promisor. Second, agent. Where the personal consideration is not the foundation of a contract, the promisor or his representative may employ a competent person to perform it. Section 40. Third, legal representative. A contract which involves the use of personal skill or is founded on personal consideration comes to an end on the death of the promisor. The rule of law is action personalized meriter cum persona, means a personal action dies with the person. As regard any other contract, the legal representative of the deceased promisor are bound to perform it unless a contrary intention appears from the contract under section 37. Fourth, third persons. When a promisee accepts performance of the promise from a third person, he cannot afterwards enforce it against the promisor. Section 41. Now, joint promisor. Last. Devolution means passing over from a person to another. When 2 or more persons have made a joint promise, they are known as joint promisors unless a contrary intention appears from the contract, all joint promisors must jointly fulfill the promise. If any of them dies, his legal representative must jointly with the surviving promisors fulfill the promise. If all of them dies, the legal representatives of all of them must fulfill the promise jointly. Section 42. The few things are rules in the regarding A. Any one of the joint promisors may be compelled to perform section 43 para 1. B. A joint promisor compelled to perform any claim contribution section 43 para 2. Now C. If any one of the joint promisor makes default in the contribution, the remaining joint promisors must bear the loss in equal shares. Section 43, para 3. So, these are the performance of contract. Now, we'll see the, okay, now the tender comes. Tender. Sometimes it is happen that the promisor offers to perform his obligation under the contract at the proper time and place, but the promisee does not accept the performance. This is known as attended performance or tender under section 38. A tender of performance is equivalent to actual performance. It excuses the promisor from further performance and entitles his to sue the promisee for the breach of contract. Now, requisites of a valid tender. Tender must be unconditional. A valid tender must be unconditional. It becomes conditional when it is not in accordance with the term of the contract. B. Tender must be of whole equity. A void tender must be of whole equality contracted for the or of whole obligation. A tender of an installment when the contract stipulates payment in full is not a valid contract. Third, tender must be by a proper person. Tender must be by a person who is in a position and is willing to perform the promise. Tender must be made at proper time and place. D. It must be made at the proper time and place. A tender of goods after the business hours is not a valid tender. Now E. Tender must be made to the proper person. A valid tender must be made to the promisee or to his duly authorized agent in the proper form. F. Tender may be made to one of the several joint promises. Tender to any one of the several joint promises has the same effect as if the tender was made to all of them. Now G. In case of tender of goods, reasonable opportunity for inspection of goods. tender of goods must give a reasonable opportunity to the promisee for the inspection of the goods. A tender of goods at such time when the other party cannot inspect the goods is not a valid tender. Now H. Tender of money must be in legal tender money. In case of tender of money, the debtor must make a valid tender in the legal tender money. If the creditor refuses to accept it, the debtor is not discharged from making the payment. Now void agreement. What is void agreement? Void agreement. It is said that an agreement not enforceable by law is void. Section 2G. Therefore, a null agreement does not give rise to any legal consequences and is void ab initio. Agreement is not an agreement at all from its inception. An agreement cannot be enforced if it includes illegal consideration or is created by incompetent parties, or it violates the basic principles of equity, or is contrary to legal or moral standards are called null agreement. Void agreements have no legal status at all. All agreements is void if it does not fulfill all the conditions of enforceability. There are few agreements which have been expressly declared void under various sections, and they are: first, agreement by a minor. A person who has not completed 18 years of age is a minor. The law acts as guardian of minors and protect their rights. They do not have the ability to judge what is good and what is bad for them. Consequently, when a minor is accused of obligation and the other contracting party seeks to enforce these obligations against the minor, the agreement is considered void. Second, agreement with a person of unsound mind. A person who does not have a healthy mind or whole mental power are not fixed, or whole mental condition is not under their own control, any agreement on the part of a sick-minded person is absolutely void, because he does not have the capacity to judge what is good and what is bad for him. Third, agreement is restraint of marriage. Everyone enjoys the freedom to marry, and in accordance with Article 26 of the contract law, any agreement is the restriction of the marriage of any person who is not a minor is null. The restriction may be general or partial, but the agreement is void, and therefore an agreement that agrees not to marry at all, or a certain person, or a class of a person, or for a fixed period is void. Fourth, agreement in restraint of trade. The Constitution of India guarantees the freedom of commerce for each citizen, and therefore Article 27 declares that any agreement by which it is restricted to any of exercising the legal performance, trade or business or any kind is in that sense null. No person is liable to deprive himself or the fruit of his work, ability or talent by any contract he enters. Fourth, wagering agreements, an agreement between two persons under which money or money's worth is payable by one person to another on a happening or non-happening of a future uncertain event is called a wagering event. Such agreements are change oriented and therefore completely uncertain. Betting this wagering agreement as it relies on an uncertain event and only one of the two parties benefits from it, as such any one gain would the other loss. Hence, it defeats the rule of contract and is considered void. Sixth, agreement in retain of legal proceedings. Any agreement by which any of its parties as restriction or enforce their rights under a contract by the usual legal procedures in the ordinary court, or that limit the time in which they can assert their right is null or void. 7. Uncertain agreements. Agreements whose meaning is not certain or can be assured are null and void. Section 29. Though Section 29, the law seeks to ensure that parties to a contract know the price, nature and scope of their mature right and obligation under the contract. 8th, agreement contingent on impossible events. Contingent agreement to do or not to do anything if an impossible event occurs are null. Whether the event's impossibility is known or not by the parties to the agreement at the time it is made. Section 36. 9. Agreement to do impossible act. An agreement to do an act impossible in itself is void. Any act that the law or the course refers to as impossible to perform cannot be contracted. If any person get into an agreement for such impossible act is void. 10. Agreement made under a mature mistake of or fact. Section 20. A mature or bilateral mistake is emerged when both the parties to the contract have entered into it on a basis of common mistake or their parties regarding anything as to the subject matter and performance of the contract. Bilateral mistake is the real mistake. A bilateral mistake is one where both the parties are under mistake and the mistake related to some material fact about the subject matter. The material fact related to the subject matter could relate to the existence, identity, equality, uh, quality of the subject matter, or capacity and identity of the performance. Such agreements are expressly declared void. 11. Agreements the consideration or subject of which is unlawful. Section 23. A contract should not only be based on the mature consent of the competent parties, but should also have a legal purpose. If the subject of an agreement is the performance of an unlawful act, the agreement is not enforceable. Section 23 claims that the object or consideration of an agreement is not legal in certain cases. The words object and consideration is in section 23 are not used in same manner. They have different meaning. The word object means purpose of design. In some cases, the consideration of an agreement may be legal, but the purpose for which the agreement is signed may be illegal. In such cases, the agreement is void. As such, both the object and the consideration of an agreement must be legal, otherwise the agreement will be void. 12. Agreements, the consideration or object of which is unlawful in part. Section 24. An agreement must have a lawful object and a lawful consideration. If the object or consideration of an agreement is the performance of an unlawful act, the agreement is unenforceable and void. Section 23. 13. Agreement made without consideration. Section 25. Consideration is one of the essential and most important factor of a void contract. It is compulsory to have consideration to formulate a void contract. Hence, any agreement without consideration is void. The law is only considered with the presence of consideration and not the proportional. 14. In case of reciprocal promises to do things legal and also another things illegal. The second set of reciprocal promises is a void agreement. Section 57. If an agreement involves two sets of promises, one which is legal and the other which is illegal, the entire contract is tainted by illegality unless and until the illegal portion of the contract is separable or removable. Now, contingent contract. What is contingent contract? Contingent contract. Contingent. According to section 31 of Indian Contract Act, a contingent contract is a contract to do or not to do something if some event, collateral, or means attached to such contract does or does not happen, like goods sent on approval is a contingent contract, like A agrees to sell a certain pieces of land to B. In case he succeeds in the litigation considering that land, this is a contingent contract. Thus, there are three essential characteristics of a contingent contract. First, its performance depends upon the happening or non-happening of a futuristic event. Second, the event must be uncertain. Third, the event must be collateral, like incidental to the contract. Contracts of insurance, indemnity and guarantee are the common set instance of a contingent contract. Now, rules regarding contingent contract. Few are the important rules regarding contingent contracts. First, contingent contract depends on the happening of an uncertain future event and cannot be enforced until the event has happened. If the event becomes impossible, such contract becomes void. Section 32. Second, where a contingent contract is to be performed if a particular event does not happen, if its performance could be enforced when a happening of the event becomes impossible. Section 33. Third, if a contract is contingent upon how a person will act at an unspecified time, the event shall be considered to become impossible. When such person does anything which renders it impossible that he sounds so act within any definite time or otherwise, then under further contingencies. Section 34. Now, fourth, contingent contract to do or not to do anything if a specified uncertain event happens within a fixed time becomes void if the event does not happen or its happening becomes impossible before the expiry of that particular time. Section 35. Fifth, contingent agreements to do or not to do anything if an impossible event are void, whether or not the fact is known to the parties. Section 36. Okay, now after contingent contract and rules regarding contingent contract, we will see the quasi contract. What is quasi contract? Quasi contract. Under certain circumstances, a person may receive benefits to which the law regards another person as better entitled or for which the law consider he should pay to the other person, even though there is no contract between the parties. Such relationship is remained as quasi contract. Law of quasi contract is also known as the law of restitution. Strictly speaking, a quasi contract is not a contract at all. A contract is intentionally entered into, but law, on the other hand, creates a quasi contract. Kinds of quasi contracts. Section 68 to 72 of the Indian Contract Act deals with 5 kind of quasi-contractual obligation. They are: first, supply of necessaries. Section 68. If a person incapable of entering into a contract or anyone whom he is legally bound to support is supplied by another which necessaries suited to his condition in life, the person who has furnished such supplies in entitled to be remained from the property or such incapable person. Second, payments by an entered person. Section 69. Payment by an interested person. Person who interested in the payment of money which another is bound by law to pay and who therefore pays it is entitled to be remains by the other. However, certain essential requirements should be fulfilled, as under the payment made should be bona fide for the protection of one's interest. The payment should not be a voluntarily one's. The payment must be such as the other party who bounds by the law to pay. Obligation to pay for non-graduation Acts, Section 70. When a person lawful does anything for another person or delivers anything to him, not intending to do so, gradually the such other person enjoys the benefits thereof. The latter is bound to make compensation to the former in respect of or to restore the things to done or delivered. However, 3 conditions must be satisfied. 1. The things must have been done lawfully. 2. The person doing the act should not have intended to do it gradually. 3. The person for whom the act is done must have enjoyed the benefits of the act. 4. Responsibilities of finding or goods. Section 71. A person who finds goods belongings to another and takes them into his custody is subject to the same responsibility as a bailee. He is bound to take as much care of the goods as a man of ordinary would under similar circumstances take of his own goods of the same bulk, quality and value. He must also take all necessary measures to trace its owner. If he does not, he will be guilty of wrongful conversation of the property till the owner is found out. The property in good which vests in the finding and he can retain the goods if is owned against his whole word. The finder can sell the goods in the few cases, like when the things found is in danger of perishing, when the owner cannot with reasonable be found out. Third, when the owner is found but he refused to pay the lawful charge to the finder, and finally when the lawful charges of the finder into respect of the maintenance of the things found amount to 2/3 of the value of the things found. 5. Mistake or Section 72, mistake or coercion. The person who to whom money has been paid or anything delivered by mistake or under coercion must repay or return into the person who paid by mistake or under concerns. The word concerns is used in general sense and not as defined in section 15. Okay, with this note we conclude our today's lecture. Few long question and short question can be asked with this from this lecture. First, it can be asked, what is performance of contract? Discuss in detail. Then second, what is tender? Discuss. Requisites of a void tender. What is void agreement? Describe in detail. Contingent contract? Discuss in detail. And last, what is quasi contract? Discuss in detail, or it can be asked in short notes also. With this note, this is in continuation. We'll meet in another next lecture. We'll continue this unit with this note. Thank you so much. Thank you very much.